Hi, my name is Grace Goodman and I work here at the Nieves law firm. Today I want to discuss with you drug DUIs, but specifically marijuana DUIs. In California, marijuana is legal, but unlike some other states, there is no legal limit that you need to be under for operating a motor vehicle while under the influence of marijuana. There are three things that the state needs to prove in order to convict you of a marijuana DUI. They are exactly the same as other drug DUIs, but these are the three things. First, they need to prove that you are operating a motor vehicle. Second, they need to prove that you are under the influence of a drug, including but not limited to marijuana. And three, because you are under the influence of a drug, you were not able to safely operate a motor vehicle. Now, in California, as I stated, there is no legal limit for operating a vehicle and being under the influence of marijuana. This is a problem because marijuana, unlike alcohol and other drugs, can stay in your system for an extended amount of time. For example, if you smoke or ingest weed a week before you operate a motor vehicle, that marijuana could still very well be in your system when you operate that motor vehicle a week later. So say you are operating a motor vehicle a week later and you are pulled over for a marijuana DUI and you submit yourself to a chemical test or a blood test. As I stated, chances are high that there will be marijuana found in your system and you will be arrested for a DUI, even though you are not under the effects of marijuana. Now, these cases specifically are extremely hard for the prosecution to prove because that second element of not being under the influence of a drug while operating the motor vehicle is the hinge that most offenses rely on. Now, a drug DUI and a regular DUI have what are called mandatory minimums, and they are the same. The second time you get a DUI, you will have to spend a mandatory minimum of 10 days in custody or a custody alternative. The third time, 120 days in custody or a custody alternative. And the fourth time, 180 days in custody or a custody alternative. After 10 years, they become what is called a stale DUI and they drop off. Meaning if you got a DUI in 2010, in 2020, that DUI would drop off. So if you got one in 2021, that would now become your first DUI, even though you got one a decade prior. Drug DUIs, specifically marijuana DUIs, are very intricate, and the laws in California are constantly changing. If you've been arrested for a drug or a marijuana DUI, I urge you to find counsel or to reach out to the Nieves law firm to see if we can help you. Thanks so much.